Hi, this is Curt, and welcome to another edition of Fire Law Roundup.
Hawaii. This is a really novel, interesting case. The facts are not difficult. And maybe it's dependent heavily on Hawaii's state laws, but look, the facts are simple. There was a underground fire, a brush fire that was burning in 21. And by the way, this is a lawsuit. These are allegations. This is not a court's finding. So we're just reciting what's alleged, not our belief. So, as always, there's a brush fire burning in April of 21. Apparently, the flames had gone underground, and allegedly, the fire department knew it was burning underground, and allegedly, they knew that the ground was unstable. A firefighter who had been out on leave comes back, is assigned to the brush fire, and sees it, flaring up every so often. And the captain says, allegedly, go out and, head out there with a fire hose. And then upon walking to the flare up, the firefighter falls into a pit of burning fire, allegedly waist deep, where the fire had been burning, apparently. And there was nothing to support the ground, they claim. They claim that everyone else knew about the dangers, that the department knew about the danger, the chief knew about the danger, the captain knew about the danger, but the plaintiff says that she didn't know about the danger. And effectively, the lawsuit, this is what's key, says that there were reports of 3 to 4 burn injuries suffered by members of the public in this area due to the underground fire, and that the fire department and the other actors were negligent, gross negligent, reckless, because they should have known about the danger and failed to warn and in fact, directed, allegedly, the plaintiff to go stand on what they knew was a dangerous place, which raises an amazing legal question, which I think turns out in the fire department's favor. Again, we're not saying, one person was right or wrong, but as a matter of law, my prediction, and Curt, let's talk about this, is that the fire department wins. I mean, we always know there's a danger of something, right? It's hard to imagine that captain knew that specific area was specifically dangerous. And I think that's what it would take to win this case, if it could be won at all. Remember, in most states, there's a law that says all you get from your fire department and your employer are comp benefits, work comp, or maybe enhanced workers comp, but you can't sue for pain, suffering, and everything else. But again, Curt, before I throw this back to you, what do you think? I'm to the point of, unless they knew that specific location was dangerous, there's no liability. It's like saying, look, the house is on fire, we're sending you in. Well, it's dangerous. You just don't know a specific area is dangerous.
Yeah, I think that's a good analysis. And I don't know if you had a chance to kind of go through the complaint line by line. One of the things that struck me was that, Hawaii is different than certainly Rhode Island and New York, and our pleading requirements are different. But the complaint is pled in conclusory terms, like saying that the department was negligent. But we know basically the 4 elements of negligence. And one of them is duty. One of the most important ones is duty. And nowhere in the complaint does it say that either that captain had a duty to warn her, or the chief and the deputy chief were also sued. So I think there's some concerns there about the way it was pled. I think there's some defects there. They stated in conclusory terms that there was negligence, there was gross negligence, there was recklessness, there was willful wanton, and so on. But you're not supposed to get away with just stating things in conclusory terms. Now, maybe Hawaii is laid back in a lot of different ways, and maybe their judicial system is, and which is fine. I mean, that whatever works there. But I was looking for where the legal duty, which is really going to be important for them to establish. I think that gets to your point that I think it's one thing if they didn't like this person and they knew there was a danger and they said, aha, we're gonna get this person, and they allowed it to happen. That's one thing. But I just don't see. I don't know. I just don't see that there's a duty. And there's also, I would think that captain would assume that this person was aware, as the captain was, that this was a problem. a problem area, that they had been there previously. So I think that there's a lot of factual issues there. One of the probably strongest defenses that the department has is the workers' comp exclusivity. And she was a volunteer. So now one of the questions becomes, does their workers' comp coverage provide exclusivity for volunteers? And that'd be over. If it was a career firefighter, I think the case would be, over and done with on a motion to dismiss because of workers' comp exclusivity. That's your exclusive remedy. If you're an employee, you get hurt, that's your exclusive remedy. There are some exceptions, recklessness, and which I just don't see recklessness here. Even gross negligence. I mean, it's unfortunate. It's tragic. We could say maybe it shouldn't have happened, but at the end of the day, at worst, I see negligence. Not, I mean, unless we're missing something.
I don't see how. I'll address your first point. Is most states, at least I know, New Jersey, New York, and many others, the volunteer firefighters benefits are the exclusive remedy, right? So I think that's a tough hurdle to get against her department. So, and I agree. I think the negligence, there's a lot of cases about traps. When you plant a trap, there would be liability, right? And now I've never seen an employer planting a trap or knowingly send somebody into an area which they know is going to collapse, right? But shy of that level of proof where it was intentional conduct, that I intentionally sent you over there, I just don't think this is ever going to get past the motion phase. I would expect that Hawaii is going to come back with a motion to dismiss, saying that, workers' comp barred by volunteer workers' comp, stating that, maybe the liberal pleading requirements, most courts will let them through that, but who knows? And certainly you haven't alleged.
I know I would have gotten, my father would not have been happy if I wrote that complaint like that. My dad would not have been happy with me.
and it's funny. I was always told you could do notice pleadings, very general. And my complaints are like 30 pages. If you ever look them up, I am so specific. So I agree with you. That's how my father taught me, and that's how we do it. But and look, as things flush out in discovery, so be it, right? But here, I think as a matter of law, this probably gets dismissed. I'm saying that only applying the law I'm guessing is the law in Hawaii. So, but very interesting suit. This would open the Pandora's box that every time a fire department knew there was a heightened danger, like a structure fire in a lightweight truss building, they would say, oh, didn't you know after 5 minutes there's a likelihood of collapse? Well, yes, but we still have to put the fire out. Right here, they still let it put the fire out. What's the other option? Nothing? Do nothing because it's dangerous? Of course it's dangerous. Our job is very dangerous. So, okay. So I don't mean to any discredit to their lawyer or whatever. No,
certainly no. It's just, I mean, different states are different, and I know Hawaii is laid back in a lot of different ways. And that's one of the things we love about Hawaii. So.